It's my pleasure to be here. I'm glad, as Miriam said, there's no snow this evening. As a lawyer, the first thing I have to do is give a disclaimer. What I'm about to present is for general information purposes. I'm not giving a legal opinion. If you have any questions, I'm always open to questions either at the end of the session or privately afterwards. But what I'm preparing and giving to you today is not a formal legal analysis or opinion. That being said, the first thing that I wanted to comment or bring to your attention is that there are basically four legal instruments that people should consider executing at various points in their lives. Some things at some points, all of them should be done, sometimes two, three, and sometimes only one. The first one, which I will talk about, is the power of attorney. I'm not sure how long people here generally have been in Israel, but anybody want to take a guess as to some of the circumstances in which one might have to or want to give a power of attorney? Any suggestions? Yes?
Care of a child during a parent's absence would be a limited one.
Okay, care of a child during an absence is a good one. Yes? Elderly as well. True. Run your affairs. True. Israel is much different. Actually, I should ask perhaps a preliminary question. How many people here are from the States? Okay. So in the States, generally speaking, excuse me?
Some of us are from elsewhere.
From elsewhere, okay. But the vast majority from the States, and I can only really speak to experiences in the States, powers of attorney in the States are used for limited purposes. They're not as popular as they are in Israel. In Israel, virtually anything that a person wants somebody else to do on their behalf requires a written power of attorney. Basic examples: if you want your car to be inspected and you want somebody to do it for you, you have to give them a power of attorney. You can't just show up without the authorization. If you want to change, divert your mail and you want to have somebody go to the post office for you, you have to sign a power of attorney. The two big issues, generally speaking, is litigation. If you need to go to court and you want to have a lawyer represent you in court. So in contrast to the States, in Israel a lawyer must have a written power of attorney in order to appear in court. The other big one, which most people often do when they go to buy an apartment or a house, you generally have to give a power of attorney either to the lawyer for the other side or very often to the mortgage company or the bank from whom you're receiving the mortgage. So the type of power of attorney can be extremely narrow. So for instance, to go to the post office can be a very limited power of attorney, versus a general power of attorney, which authorizes somebody to take all acts and use all authority that you yourself could use if you were able to for various reasons, but couldn't. So for instance, somebody came to me today. They are about to go to Hutzlaritz on a trip, and they want to make sure that their daughter has the authority to go to the post office, to pay the rent, to deal with all kinds of issues. In that case, we prepared a general power of attorney. But if the purpose of the power of attorney is more limited, so then by its nature, the document will be much shorter. As a result, or connected with it, there are different certification processes for confirming the authenticity of that power of attorney. So usually, for instance, if you need a power of attorney to go to the Motor Vehicle Bureau to take care of licensing issue or inspection of your car, or to sell the car, usually that requires only the certification of an Israeli lawyer, whereas a power of attorney for use for the purchase or sale of a house or a general power of attorney requires the certification of an Israeli notary. An Israeli notary is different than a notary in the States. Virtually anybody can get a notary license in the States if you pass a civil service exam, or if you're a lawyer in many states, it's automatic. You just have to apply for it. once you pass the bar. In Israel, the concept of a notary is from ancient times, recognizing the British system, and only a lawyer, you could call it a super lawyer, but a lawyer who has at least 15 years of experience, has gone through various application processes, has been examined by Misrad HaMishpatim, can only get the authorization to be a notary. So general powers of attorney require a notary certification. Many limited powers of attorney can be certified by a regular lawyer alone. Obviously, if you're giving a power of attorney to somebody else, it has to be somebody that you trust. The broader the power of attorney that you're granting, the more you should be comfortable with the person who you are authorizing. Certainly, a general power of attorney, which gives authorization to somebody to do everything that you yourself could do, should only be given in limited circumstances, either to immediate family members or to close friends that you trust imminently, before you give them that general power of attorney. Now, a power of attorney in Israel is usually only effective when the person is mentally capable, still mentally capable, but for whatever reason can't physically attend to his or her needs. Maybe they just broke a leg, maybe they're laid up in the hospital, maybe they're going abroad and they want somebody to cover their needs. But the person must be mentally capable in order for the power of attorney to be effective. So if the person becomes afterwards no longer mentally capable, the efficacy of the power of attorney would lapse. Whether or not the recipient of the power of attorney would be aware of that's a different story. But if it were to be examined to ascertain whether the person who granted the power of attorney was actually capable at the time, their mental condition will be determinative as to whether or not the power of attorney that was used is effective. As it says in the slide, if the person is no longer mentally capable, the only alternative at that case is to get a guardian appointed for the individual. You apply to the court will appoint somebody to make decisions on behalf of the person that's no longer mentally capable due to senility, Alzheimer's, etc. And that is the means by which you can address the mental incapacity of somebody but still be enabled to make decisions and act on their behalf. The exception to the rule regarding a lack of mental capacity invalidating a power of attorney is if the power of attorney is for the benefit of a third party. So for instance, I mentioned previously a power of attorney is very often given when a person buys or sells an apartment. So the authorization is usually given in favor of the lawyer for the other side. If you are the buyer, it's given to the seller. If you're the seller, it's given to the buyer, in order to authorize the other side to consummate the transaction if for some reason the person themselves skips town, passes away, becomes mentally incapable. So at that point it's important for the counterparty who relied upon the power of attorney for it to continue even if the person is no longer mentally capable. The next type of power of attorney or instrument is a healthcare proxy. The healthcare proxy actually works almost the opposite of a general power of attorney. Conceptually, again, a person is giving the authority to somebody else to take acts or make decisions on that person's behalf. But in contrast to a regular power of attorney, the healthcare proxy is only effective if the person is not at the time mentally able to make decisions on their own behalf. So for instance, if somebody is going into the hospital and expects to go into surgery, so the healthcare proxy would become effective only at the time when the individual is not able to make his or her own decisions regarding their health care. If you have a a healthcare proxy signed now, and God forbid you're in a car accident or you fall on the street and you're unconscious and not able to make healthcare decisions on your own, the healthcare proxy will kick in to enable somebody else to make the healthcare decisions which you are not at that time capable of doing. What is unusual in the case of Israel, in contrast to the United States, for instance, is that the authorization given by the healthcare proxy can be overruled by a committee of doctors if 3 doctors get together and disagree with the approach given, the authorization or the instructions given by the person who holds the power of attorney. They have the authority to overrule the instructions and the decisions of the proxy holder. So, for instance, if the person who holds the healthcare proxy says, I want person X, the person who gave the authority to have a certain procedure, and the doctors feel it's inappropriate, usually the opposite is the case, where the person who holds the authority says, I do not want a certain procedure to be given to this person, the doctors can form a committee of 3 in order to overrule the decision made by the proxy holder. Now, what happens in the event that the proxy holder still disagrees with the decision that's been overruled by the 3-person doctor committee? Unfortunately, at that point, lawyers get involved, it goes to court, and a court would have to make the decision. Each side will then present their case to the judge as to the position that they want to take. And it'll be up to the judge to determine whether the decision made by one party or the other is the best decision to be made. Well, we'll see what happens. Now, until recently, the healthcare proxy was only available in Hebrew. What our firm did a couple of years ago is we took the Hebrew language form and we had it translated side by side, even though we tell people that the Hebrew side is the side that should be completed, but at least this way they understood what they were signing and completing on the Hebrew side. Recently, the Ministry of Health came out with an English-only version. Now, the form that we put together, we spent a considerable amount of time on it. We do not charge for the use of the form. Anybody that wants is welcome to have it. It's a service that we provided to help English speakers. Perhaps we should have done it in other languages as well, but I'm limited to Hebrew and English. In my opinion, even though there is now the English language only form, this, together with the next document I'll speak about in a second, is meant for crises situations in hospitals or medical care facilities. At that point, while there are many doctors who speak English, it is in your interest to have the documents in Hebrew that the doctors will be able to make quicker decisions than they would if they had to try to figure out what the English means. So that even though you could, at this point, use the English-only form, in my opinion, if your Hebrew is good enough, you should use the Hebrew language form, and if your Hebrew is not good enough, to use the joint form that we prepared. But again, the version that is now available in English should suffice as well. The next document that, were you to be able to see the presentation, you'd see that we're talking now about a living will. So in Israel, the living will is called an advanced medical directive. It is only effective when a person is actually dying. A living will in the States has a strange connotation. It's not about living, it's actually about dying, and what procedures an individual wants, what kinds of care they want. It's quite a detailed form, whereas the healthcare proxy It needs to be signed only by 2 witnesses, and those 2 witnesses can be a doctor, a lawyer, social worker, psychiatrist, or nurse. The living will, or the Advanced Health Directive, must involve the participation of a doctor who must certify on the document itself that your physical condition, that they've explained to you the medical ramifications of whatever decisions you make. The healthcare proxy, the document I spoke about previously, has very limited options and choices that you can make on it. The Advanced Medical Directive is quite detailed. The living will form has, as part of it, a healthcare proxy as well, actually an even shorter version of what is in the healthcare proxy form itself. I would suggest that most people, regardless of their age and their physical condition, should have a healthcare proxy in place, because, as I said previously, you never know when something unexpected might happen that would prevent you from making decisions on your own. In many hospitals in the United States, as soon as you are hospitalized, one of the documents that the hospital requires you to sign, there we go, is a healthcare proxy to make sure that there is somebody able to make decisions for you, legally authorized if you can make them on your own. They don't generally do so regarding the living will. The living will is something that, again, you require your usual doctor's input. It is a lengthy form with many, many choices in them, and it's something that you should obviously consider very carefully before you make your decisions. This is just, excuse me?
Active touching of the screen keeps this going, like every couple minutes, just to hit your space bar.
Gotcha. Okay. So this is, again, a sample of the form that we prepared. Again, previously the form was only available in Hebrew. It is now available in English only. Similar to what we did with the healthcare proxy, we did a side-by-side translation of the living will, and again, in my opinion, probably less urgently than in the case of the healthcare proxy, I still think you should use the Hebrew form if your Hebrew is at a level which is high enough. There are many technical terms in there, so even if somebody is generally comfortable with Hebrew, I think if you have to be familiar with medical terms, so I think you should at least either take side by side on your own the 2 different documents in Hebrew and English, or again, you're more than welcome to use the form which we've come up with, and anybody that wants it is welcome to ask.
Could you go back to the previous slide?
The previous slide, I'll try. Did I do that? Is this the previous slide?
Yes.
Okay.
Are these documents on your website?
That's an actually good question. It is not, but I'll make sure it'll be put on there. We're actually in the process of redoing our website,
What is the website?
website is www.lmf, as in Larry Michael Francis, .co.il. I'll make a point of putting it on the website. That's a good suggestion. Thank you. The forms are printable from either by email, or I'll make sure that they're put onto the website. And my suggestion is, if you're going to go to the bother of doing this in the first place, you should do it in a way that it's convenient for the doctors to understand what your intentions are, and that obviously it's important that you do as well. Now, I'll have to say that I've been dealing with these 2 documents for many, many years. Healthcare proxy is very frequently used by many people, even if they're in good health, even if they're relatively young, as a backup for whatever instances might occur. In all the time that the law has been in place to require the specific living will form used in Israel, nobody has come back to me afterwards and said they've actually done it. Now, There may be several reasons why that might be. People may not be comfortable sitting with their doctors going over their choices. Doctors may not be as comfortable spending their time sitting with people to go over the form. Decisions regarding end of life are difficult ones, and therefore people may be hesitant in concretizing and putting down their wishes. But these are decisions that are important to make at times when you're not under pressure, and in my opinion, it's something that should be seriously considered, certainly if somebody is in less than ideal health. I'll give an example of a problem. About 2 years or so, I received a very urgent call from a business associate who happened to be in the hospital with his wife, and he contacted me because an elderly non-Jewish person was on one of the Christian missions to Israel, and this woman, an elderly woman, had a stroke while she was here, and for all intents and purposes was declared brain dead by the doctors in the hospital in which she was hospitalized at the time. And they contacted the daughters who lived in, I believe it was Florida. The daughters sent the U.S. form of living will that this woman had signed, asking to be disconnected from life support in the event that she was declared brain dead. But the hospital wouldn't accept it. The hospital took the position that in Israel we only accept now the Israeli form of living will, and they were insisting on maintaining the physical functions of this person and were not willing to disconnect life support. The daughters came over, they argued, they cried, they came to me, and they didn't know what to do. So we did what lawyers did. We threatened the hospital. We threatened to go to court. There was no question that the woman was considered by them themselves to be brain dead. Nobody was willing to pay the cost of care in Israel for this woman, that they just wanted to bring her body back to the States to be buried. And ultimately, the hospital ended up caving in. I would call that probably an unusual circumstance for lots of different reasons. But the point is that even if you have a living will from the old country, if it's important enough for you in the first place to have done it the first time, and you're now living in Israel, in my opinion, you should do it right now. This form, as the healthcare proxy, doesn't cost anything for you. Either the form that I prepared doesn't cost anything. You can download the Ministry of Health form or the Hebrew language form, which is available, I believe, in the Justice Ministry. So it doesn't cost you anything to obtain the form. You might have a cost for your doctor to assist you in preparing it. Not the case regarding the healthcare proxy, but it's something that, since it doesn't cost you anything, it's just a matter of effort and making the tough decisions. In my opinion, it's something that people should seriously consider, certainly as they get on in years, and certainly if there are any health issues that come up. The next subject that I want to talk about is probably the one that most of you came here to hear, and that is testamentary will, which is what we commonly think of when we think of a will. I just want to go over one clarification that I said previously about no cost involved regarding the documents. That is the case regarding the healthcare proxy. That is the case regarding the living will. That is not the case regarding a general power of attorney. A general power of attorney will have two costs involved usually. One is the cost of the lawyer in preparing the document. Even though it's a relatively straightforward document, there are some issues that need to be considered, so there's a cost involved with that. And there's the notary cost, which is set by law. That usually is approximately 170 shekel plus VAT for the certification, and most lawyers will charge around 150 shekel plus VAT for preparing the power of attorney. So that's the first document. I don't necessarily recommend that any of you rush out to do powers of attorney. In my opinion, it's unnecessary in most cases. There's no reason to spend the money. There's no reason to entrust your authority to somebody else, so I wouldn't rush out to do that. The healthcare proxy, I think you should do because there's no cost involved. And the living will, the advanced healthcare directive, is something that you should consider without any cost if you are approaching a time where you might be concerned about those kinds of choices. Anyway, getting now to the testamentary will. I very often have clients come to me, or potential clients that come to me and say, I want a very straightforward will, or why do I need a will? I know where everything's going to go. It's going to go to my immediate family. It's going to go to my children. It's going to go to my surviving spouse, if they have a spouse at the time. But there are many reasons why a will should be seriously considered up front in order to express your wishes that can be taken care of after 120. The first one is to determine who inherits what. I'll go into that in a little bit more detail in a second, but usually when people think of wills, the first thing they think about, which is the correct thing to be concerned about, is who inherits what property of the person when he or she passes away. And there's no question that is probably the number one reason for doing a will, and it is sometimes the most complicated, even though many people will say that they have very simple instructions. The other is who manages the property in your estate after you pass away. There are choices that can be made. I'll talk about that in a few moments as well. In the context of preparing your will, that particular authority is called, the person nominated is an executor, that's the male version, or an executrix is the female version. I'll address that later. I don't want to spoil the surprise when I talk about the difference again between the United States and Israel. If you have minor children, then you can express your preference in your will as to who will care for your minor children in the event that both parents are not around, to avoid arguments among heirs. Again, that's connected with the first part. Many times, often again, people will come to me and say, well, I want everything split among my children. And unfortunately, today, when everybody's one big happy family, you can envision people making casual decisions or joint decisions in a familial way, but unfortunately, from my experience, I've seen many instances where fighting erupts in families that could have been avoided if a will had gone into sufficient detail as to specific properties. We'll talk about that. To minimize taxes in jurisdictions which have an inheritance tax. So for those of you that are not aware, if you are a U.S. citizen, and that may be the case in other countries as well, but again, I'm most familiar in my licenses in both New York. I was licensed in New Jersey and in Israel. I'm not going to talk about other states. I'll speak in general terms about the United States. Even if you are no longer living in the United States, you are still subject to federal estate tax, just as, in case you're not aware, you are also subject to federal income tax. You are supposed to file income tax returns in the states even if you're no longer living there, a federal return, and you are subject to federal estate tax in the states. You may or may not be subject to state estate tax. I may touch upon that if time permits. But certainly if you have a significant inheritance, you should at least be aware of some of the options involved as far as tax planning is concerned, putting property into certain trusts, etc. I'm not going to talk about that in great detail. And the last point, just as a general introduction, you'll see in a second what happens automatically by law in the event that you don't have a will at all. But one of the things that will happen is that no property of yours will go to any charitable institutions. Many people want to give donations either to good organizations like Nefesh B'Nefesh in recognition of the help that they've given over the years, or any other tzedakah that you feel is close to you. You're not under any obligation to. But if you don't have that in your will, That's not something they'll be taken care of. Many people will do so in order to ensure that somebody's there from that institution to say Kaddish for them if they don't have somebody else to do it. Recognition of services that they've gotten or given, or religious affinity. So it's something to think about that wouldn't be available otherwise if you did not have a will. So again, when you're considering doing a will, you have to think, well, what's the alternative? I don't want to do a will. I don't want to spend the money. It is expensive to do a will. And many people, again, similar to the living will, they don't like broaching the subject of what's going to happen after 120. They don't want to deal with it, and they'll say, let the state decide whatever the state decides. So I'm here going to briefly speak about what some of the alternatives are depending on your family situation. Most jurisdictions and countries will have default provisions, just like the United States does. Individual states in the United States have their own rules, and Israel has its rules as well. The primary heirs by default, by law, are the surviving spouse, if there is a surviving spouse, and the children of the deceased, if there are children. And then the distribution goes in different directions depending on specific situations. So if a person has, let me go back for a second if I can, if a person has a surviving spouse and children, so the surviving spouse would only be entitled to 1/3 of the estate, together with personal effects in the house, and the balance, the other 2/3, would be divided among the children. Now, from my experience, most people that come to me don't have that in mind. Most people, if they're married, want their surviving spouse to get everything, perhaps other than specific items, and only if at the time there is no surviving spouse for the property to go to children. But this is the rule that applies by law in the event that there is no will and there is a surviving spouse and children. The surviving spouse would get the contents of the home and the car, and then the balance split among the children, the 2/3 of the interest. Here I give an example. If there's surviving children, the spouse gets half, children receive, or the parents receive half, and then 2/3, so I'm not going to go into those details right now. Also, if the person does not have a will, but had a surviving spouse to whom they were married for at least 3 years and lived together in the marital abode, so the distribution by default of law is different than it would be otherwise. But usually, again, most people, when they're considering doing their will, that's not the distribution process that they have in mind. Excellent coffee. It's my daughter in the front row. She made great coffee for me. So again, when you're considering now, you're in the process of thinking about preparing your will. What we do in our firm, because I've been doing this for so many years, we developed a questionnaire which has all kinds of details. Maybe I'll add that to my slides in the future, or perhaps on my website. But it's a multi-page document which goes into all kinds of details as to the individual who's preparing for whom the document is being prepared, their spouses, their children, their age, their misparei zehut if they're Israeli citizens, their U.S. passport numbers or Social Security numbers if they're U.S. citizens or from whatever country they may be in. It will go into detail as far as your assets are concerned, whether it's interests in an apartment, stocks, bank accounts, and how you propose to distribute the various assets that you have. And then the last page, I go into various historical details of the individual who's preparing the questionnaire and seeking our guidance. Now, that form is useful for many reasons. First one is it gives me, the drafter, the idea of what the issues are involved in the person that's preparing the will, what is important to them, because people don't think, if you're not a trained lawyer, even if you are a trained lawyer but you're not a trained Israeli lawyer, there are many differences between Israeli law, which I'll talk about again in a second, than that in other countries. And by my knowing to ask the questions and getting your feedback, it gives me the opportunity to respond to various concerns that you may not have been aware of to raise and to discuss with you before we prepare the will itself. One of the issues, as I referred to previously, is the appointment of an executor. Now, in the states, in most states, again, my greatest familiarity is with New York and New Jersey law. I would say 95% of the time when you designate an executor in a will, the process that the court goes through, what's called the probate process of the will result in the appointment of usually those individuals designated as executors, and those executors are the ones that will manage the distribution of the estate, will follow your instructions. This property should go to that person, that property should go to that person, in the event that there's no will or no designation as to who is the executor. So the process of the court appointing the individuals would be calling those people administrators or administratrix. In Israel, it's almost the opposite again. I would say 95% of the cases, even if you will designate in your will who you want to be your executor, in most cases the Israeli court will not appoint that individual to be an executor. What the courts, and the last line here is one of the two main reasons the courts won't do it. One is that executors are entitled to fees, and the Israeli courts generally feel they want to preserve the estate for the heirs rather than, I could use the term, squander the money on paying fees to executors. And secondly, there are fiduciary duties, filing requirements, etc., that fall upon the individual who is managing the estate if they are appointed as executors. And therefore, the courts are generally reluctant to designate officially an executor to manage the estate. So you may ask, what happens when you have the will that's being probated after 120? So the process in Israel, again, is very different. The court will examine the will and determine whether the will is valid. And if the will is valid, the court will put its seal of approval, a cover page, on usually the original of the will. And the heirs, usually together with their lawyer, will go to the various authorities and say, okay, the will which has been blessed by the court says that everything goes to the spouse. Here's a bank account in Bank Leumi. Bank Leumi, transfer everything into the spouse's name. Or I have an apartment, and the apartment is in the name of the deceased, and the will says that my apartment gets divided among my children, so that usually the lawyer or one of the other heirs will take the will with the approval of the court, present it to the land authority, and change the registration of the property. So then you may ask, why bother designating an executor in the first place in an Israeli will? And the answer is because there are circumstances where it may be necessary to appoint an executor, even though it is extremely rare in Israel. But if, for instance, there's a complication in the estate, maybe there's litigation going on, maybe you have complicated assets that require specific management, you then need to file a separate legal proceeding, leminui minaheli zavon, separate and apart from the recognition of the will, in order to get the court to consider whether to approve the appointment of the executor. At that point, the court will look to see who you preferred in your will to determine who the court will grant this special authority to. In the absence of a designation in your will, the court may look to an immediate family member, or it may look to one of its own family members. These are judges that have people that professionally or otherwise will make the 3 to 4% of the value of an estate. In the absence of your expressed preference, it is possible that a judge will choose somebody that you didn't even consider would be the person that would be earning the fee and managing your property. Care of minor children similar to the appointment of an executor, the court will not automatically abide by the decision that you give in your will as to who would be the guardian for your minor children. The default provision, if there is a surviving spouse, is that the surviving spouse would be the guardian. But there are exceptions to the rule, and unfortunately I've had experiences with very messy inheritances and wills where the family were not aware of negative aspects of the surviving spouse, which came out after the first spouse had passed away. So the court doesn't necessarily automatically accept your designation as to who would be the guardian, but again, it will take it into consideration, when making the decision. In the case of minor children, there you can, in addition to designating the guardian for the children, you can also establish a trust or trusts in your will to manage property that would otherwise go to the minor children. Many people don't want 11-year-old kids to be able to inherit significant amounts of money and go buy motorcycles or whatever kids might do if they were to have access to significant amounts of money. So you can have money go into a trust which can be managed by a third party in order to supervise the administration of the property that would otherwise go to the minor children. As I mentioned previously, one of the purposes of doing a will is to avoid conflict in the family. Many people, again, when they come to me, I have a very simple estate. I just want everything to be divided. And then when they look at my form and they ask and I ask as part of the form, what are significant personal items of value, either emotional value or actual value, that you may want to be going to a certain person, even if you have everything else go to your surviving spouse, or you want everything to be divided among your children, you may want a specific Kiddush cup, certain types of jewelry. You may want to go. Somebody just came to me last week that wanted their silver candelabra to go to their first granddaughter to get married. I thought that was an interesting idea, but the concept is that if there's specific property that you want to go to a particular person, it should be designated in your will to avoid arguments among your heirs afterwards. Or you could say, if people don't agree, to sell all the items and have the money distributed among the family members. But again, if you have a particular item that you want to go to specific people, you should designate it in the will. I had a case a few years ago where somebody did what I suggested here which I referred to, not suggested, what I referred to here on the bottom. They had a will which said everything gets divided among my children. There was no surviving spouse at the time, and this person had gone around and put tags on the bottom of various items saying this goes to this child and that goes to that child, which is a nice idea, but it's not legally binding. And then when it came time to probate the estate, there were vehement arguments among the children as to whether the preference of the deceased should be honored, and the proof being the tags that are on the items, or whether the wording of the will should be honored, which said that everything should be divided equally. It's unpleasant to be in the middle, either as a lawyer or as a family member, to see the arguments that sometimes take place among heirs, so it's better to minimize these issues up front. I touched upon briefly that everybody here, that everyone here who is a U.S. citizen and has not relinquished their U.S. citizenship, which I'm not advocating, but I'm saying whoever is still a U.S. citizen is subject to federal estate tax. The U.S. federal estate tax exemption for the calendar year 2015 has just been increased to $5.43 million, which essentially means that if you have in your estate, including all assets, less than $5.5 million, there won't be any federal estate tax. If you cannot prove that the person who passed away was living actually and the center of their life was in Israel, there may be an issue as to whether or not a state estate tax would apply, but usually that amount pales in comparison to the federal estate tax, which is quite expensive. If both spouses are U.S. citizens, then there's 100% exemption usually to the surviving spouse regarding, even if you had $10 million in the estate, the surviving spouse would not be subject to federal estate tax. And when you're making this determination, and again, that is one of the reasons why we put together our questionnaire years ago, so that we can focus people on what the property which is considered part of their estate, both for estate tax purposes and for administration of the estate. So basically, any property that is in the name of the deceased at the time where they passed away, but does not have a designated beneficiary, becomes part of the estate. Now, what gets excluded from that, putting aside taxes for a second, but if you have a life insurance policy and the proceeds of the policy are payable to John Smith, then even if your will says that everything should go to your spouse, the instructions of your life insurance policy will supersede that of your will. If you have a mutual fund, most mutual funds, at least in the States, give the opportunity of designating beneficiaries. If you've done that many years ago and you may have chosen person X that you may or may not have a relationship with anymore, or has passed away, you may want to either change or delete that designation, but as long as that designation is in place, the designation of the beneficiary will supersede the provisions of your will. I just want to touch upon another distinction between the United States and Israel, and that is regarding joint property, jointly owned property. When I refer to jointly owned property, I mean property, whether it's a bank account or an apartment or stock or any other asset which is in the name of more than one person. In the States, in most states in the United States, if you have, for instance, husband and wife who are joint property owners of an apartment or a bank account, when the first person passes away, the remainder automatically passes to the surviving spouse. Again, no matter what the will would say, if you lived in the States and you had assets in the States, the property would automatically pass regardless of what your will says. In Israel, that's not the case. In Israel, when you have jointly owned property, and again, that could be an apartment, could be a bank account or anything else, each of those owners is considered by Israeli law to own a percentage interest in the whole. So that, for instance, if you have an apartment that's owned by two people, husband and wife, each of the spouses is considered to have a 50% interest in the apartment. So when the first person passes away, it does not automatically go, in the absence of a will, to the surviving spouse. That person's half interest becomes part of the estate. So if you mistakenly thought, okay, I have an apartment that's jointly owned with my spouse or my child or my grandchild, and they're taken care of because when I pass away, it's automatically going to go to them, and therefore in my will, I'm going to designate that everything else goes to my other grandchildren or children, etc. So the person that you thought would end up with half interest ends up with nothing other than whatever they may have had their 50% interest. That may not be your preference, but it's something that you need to take into consideration when you're making your decision as to how to structure your will, how to structure your assets, designated beneficiaries, and how the two mesh together, because the The rules in Israel are very different than they are in the States. Now, when it comes time to making a will, so there are 4 main methods of doing a will, and each of them has its own ramifications, advantages and disadvantages. I'll speak about them briefly. Holographic or oral will is only effective if the person that's giving it is imminently going to die. It must be given orally in the presence of 2 witnesses. The 2 witnesses must then reduce to writing the oral will which was said to them at the time that the person was dying. And if the person survives more than 1 month, the oral will be invalid. Now, there are many, many problems with an oral will. First of all, you have no record, you have no way of proving other than the word of the 2 witnesses as to what you actually disclaim at the time that you're giving the oral will. Second of all, again, it expires after a month if you hopefully will survive. Almost by definition, and that'll be the case in some of the other types of wills also, if you're doing an oral will, that means you, unless you happen to have your lawyer sitting with you going over your assets while you're in the process of imminently dying, means you didn't have the benefit of legal advice into some of these ramifications that we spoke about at the time that the oral will is given. And lastly, you have no real proof as to whether, other than the word of the 2 individuals, as to the mental capacity of the individual at the time and whether the individual was under any kind of duress. So clearly, aside from the fact that nobody wants to be dealing with these things when they're dying in the first place, but if you've heard previously that an oral will is valid, it's true. It's only under limited circumstances and highly risky and not advisable. A handwritten will is slightly better than an oral will. It must, however, be completely in the handwriting of the person that's writing the will. Can't be typewritten, can't be prepared by somebody else and then signed. Must be in that person's handwriting. It must be signed and dated by that person. It does not have to be done in the presence of witnesses. Now, from the example that I gave with the oral will, you have many of the same issues, perhaps even more so, because here you don't even have the 2 witnesses. You can't bring into court after you the heirs can't bring into court after the person passes away and say, okay, these 2 witnesses, what was the person's state of mind at the time? Were they under pressure? Was the spouse of this person or a child influencing them at the time? There's none of that's around because all you have is the handwritten word of the person. In addition to the question as to whether or not it actually is the handwriting of the person, then you get into all kinds of disputes with handwriting experts as to whether or not this actually was the handwritten will of the individual. So it's, again, highly recommended against having a handwritten will. You won't have the advantage of legal counsel usually, because otherwise if you had legal counsel, you'd have a nice, pretty, typed up will that would be done in front of witnesses. So the mere fact that it's handwritten suggests that you didn't have legal guidance at the time. What most of us are most familiar with are typed wills in the presence of witnesses. I'll anticipate one question that I get, I wouldn't say on a daily basis, but almost on a daily basis. I get many inquiries from Olim, whether or not I'm doing their wills or not, but they'll contact me and say, I had a will from the old country, do I need a new will here? So there are at least 2 answers to that. First, if the will was done correctly in the old country and was signed according to the rules, which I'll speak about in a second regarding a typewritten witnessed will, and it still reflects your desires, your preferences from however many years ago in the old country, then the answer is yes, it will be recognized and valid in Israel. The negative aspect of that And you can do a will in English or in Hebrew or any other language that you prefer in Israel. And I always tell clients that they should do a will in the language that they're most comfortable with, because what is critical is that they understand themselves what they're designating in their wills. But a will which is not in English will generally have to be translated into Hebrew and will then require a notary certification of the translation. I happen to be a notary. I can tell you that it is extremely expensive to translate a document and to have it certified by a notary. U.S. wills tend to be much longer than Israeli wills for several reasons. One of them, the most practical reason, is lawyers can charge more money if you have an impressive long document. That's probably the real reason why in many cases you have long 35-page wills. Even assuming the lawyers did not have that interest in mind, they put all kinds of fancy tax preservation rules and trusts, which first of all may not be understood by the Israeli courts in the first place, but are not necessary, first of all, because Israel does not have currently an inheritance tax, so you're only talking about U.S. federal inheritance tax. And if you don't have in excess in 2015 $5.43 million, then most of the provisions of these long wills will be completely irrelevant anyway, and you're going to be paying, your heirs will be paying a ton of money in translating this lengthy document into Hebrew. Most Israeli wills, even if they're in English, are 6 or 7 pages long, a fraction of the cost of having a lengthy English language will done anew, and the cost of doing a new will in English, which is much shorter, will be significantly less than translating and certifying by notary the will from the old country. But the wills that we're familiar with, this types of wills, must be printed. It must be signed in the presence of at least 2 witnesses. Has to have the date. The testate, or this person that's making the will, has to sign in the presence of 2 witnesses. The 2 witnesses then sign on the will, and from my having experience, actually I'll tell an interesting story in a second, we also prepare what's called a self-probating will, primarily for use in the States if you have assets in the States as well, because the Israeli will be recognized in the States too. A self-probating will is basically an affidavit, a declaration made at the end by the witnesses, basically saying they supervised the process, the person wasn't under duress, they were mentally capable, they're at least 18 years of age. I sign as supervising lawyer, and that document can be presented in court in lieu of having to drag the witnesses into the court to verify what happened at the time that the will was signed. The interesting story is when I was a young lawyer in the States, we had a will that needed to be probated. The firm that I was working with at the time did not prepare the will, but we got this will signed in the presence of 2 witnesses, and it did not have the affidavit attached to it. It wasn't customary to do so at the time. We had to go and track down the witnesses, and it turned out one of the witnesses had died, and the other one lived in the house where John Lennon had, by Strawberry Fields, whatever. So it was actually kind of interesting going into that house and seeing the people. But I learned the lesson that it can be extremely complicated to prove the validity of the will through witnesses if you don't have the self-proving affidavit in the end, and therefore it's a good idea, and that's my standard practice, whether it's a will done in English or in Hebrew, to have the affidavit at the end signed by the witnesses with my supervising and then certifying their signatures. The last choice of doing a will is before an authority. As I say here, the authority can be a judge, court registrar, which is a quasi-judge in this country, an Israeli notary, the inheritance matters registrar as well, and various members of religious courts can certify the will being done as well. I can tell you from personal experience, I hate doing this. I hate doing it for two reasons. One is that one of the conditions is that either that official must read the will out loud to the person, or the person must sit there and read it out loud to the authority. I personally don't have the patience for that. But aside from that, although it may be the strongest means of confirming the validity of the will, it costs more money. If you have the two witnesses, you're already spending money on doing the will in the first place. Presumably you've had a lawyer prepare it so that it's done correctly. If you're doing it in the lawyer's office, in the presence of two witnesses, the two witnesses are not going to charge extra for witnessing. At least I've never heard of witnesses charging extra. But if you go to a notary, you're going to have an extra cost of having that the notary by law must charge to certify the will that either he or she read out to you or that you read out to the Israeli notary. I'll just make one other comment about notaries. Israeli notary fees are set by law. All Israeli notaries must charge the same. They can't charge more. They cannot charge less. So any notary that you go to should be charging the same thing. And again, if you can go through this expensive process without having that extra cost, and I believe that the courts will charge a fee as well, there's no real reason for doing so, in addition to the inconvenience of going to these people. An amendment to your will, I usually have a speech which I give to people after they sign the wills, that if their circumstances change dramatically afterwards, either because they come into a major inheritance or somebody that would have received fell out of favor, or the opposite, somebody that had been excluded up till now is now found in favor, and changes are necessary to be made to the will. So I suggest to people we should at least talk. There may not be anything necessary to be done to the will, or the basic change can be done in what's called a codicil, which is an amendment to the will, which must be done with the same formality as the will itself. So again, you'll have a typewritten codicil signed in the presence of two witnesses that will confirm that the person is mentally competent and not under duress at the time, and that can be affixed to the existing will. In the event that it's a major change, then I'll oftentimes tell people a codicil is not going to do it, it's going to get too complicated, you're better off doing a new will. I had a client who actually recently passed away. She was 85 years old when she first came to me, and this woman had grandchildren that sometimes she liked, sometimes she didn't like. She changed her will more often than I changed my socks. And I tried to discourage her, and I tried to get her family to discourage her, because you're dealing with a significant disposition of your property. You shouldn't make flippant decisions based on how you feel on a day-to-day basis with particular family members. And it's not a change that you should make lightly. So the first thing that I will do, depending on the nature of the change involved, is discuss whether it's something that the person really wants. In that case, actually, some of the later changes were with this woman being accompanied by a child of hers, which made me uncomfortable as well, whether or not I had to be convinced. I take it very seriously when I supervise a will, to make sure that the person is not being overly influenced by somebody else. So as an example, when somebody comes to me to sign a will, they will be alone in the room with the witnesses and with me. There won't be any other family members present, to minimize the risk that somebody will afterwards claim that this grandchild, this neighbor, this relative influenced the preparation of the will. So I try to minimize that by making sure that even if it's husband and wife, they're not in the room at the same time. As I said, a critical aspect of the validity of the will, aside from the person being no longer a minor, is that they are of sound mind and not under any undue influence at the time, and that there's nobody that's compelling them to make any particular distribution, of the property, of the will. Thank you again. There is a concept which was more familiar years ago called a mutual will, where you have a single will signed by husband and wife. That is frowned upon for several reasons. The main one is that it limits the ability of one spouse or the other to make changes afterwards, whether it's while both are still alive or even afterwards. It basically locks you into the joint will that has been made. The argument being that consideration or an anticipation was made when the decision was made in the mutual will, and how is the surviving person now going to undo it in the first place? If you're making a mutual will, the presumption is that you're stuck with it, and it's generally frowned upon for that reason, and I have not seen or heard of, and certainly not done a mutual will in, I can't remember when. And lastly, again, the most important aspect, in addition to mental capacity at the time of preparing the will, is to make sure that there was no outside influence or duress that caused the person to make specific designations in the will, and therefore I'm extremely sensitive to the issue when it comes time to preparing the will, and certainly at the time when the will is ultimately signed in my office. And with that, I thank you and would be happy to take questions.